Miranda rights are specific rights that any person who is taken into police custody is entitled to. They read, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read you? With these rights in mind, do you wish to speak to me?" There are two circumstances in which a suspect must be read these rights. They are being in police custody or under interrogation. If a suspect is not made aware of his Miranda rights, then any responses to the questions are inadmissible, as are any evidence found because of an unlawfully received response. In all circumstances, it is not necessary for the police to read a suspect his rights. If he is not formally in police custody or being interrogated, then anything he says can be used as evidence against him. Although questions about the incident are off limits without being read Miranda, there are certain questions that police can ask to establish the identity of a person. These include name, address, date of birth, and social security number. Police can also give alcohol and drug tests without Miranda warnings, but individuals being tested may refuse to answer questions. On March 13, 1963, Ernesto A. Miranda, a 23-year-old mentally ill man, was arrested for the kidnapping and rape of an 18-year-old girl. Later on, Ernesto Miranda was identified as the assailant by the victim. Prior to questioning, Miranda was not informed of his rights to counsel and the Fifth Amendment. During the 2-hour interrogation, Miranda allegedly confessed to committing the crimes, which the police recorded. Miranda, who had not finished 9th grade and had a history of mental instability, had no counsel present. At his trial, docket 759, the prosecution's case consisted solely of his confession. Miranda was convicted of both rape and kidnapping and sentenced to 20 to 30 years in prison. He appealed to the Arizona Supreme Court, claiming the police had unconstitutionally obtained his confession. While the case was in the Supreme Court, Chief Justice Earl Warren was the residing judge. He was formerly California's Attorney General and the Governor of California. Warren holds 2 law degrees from the University of California at Berkeley and practiced law for a short time before joining the Army and serving in World War I. On September 30, 1953, Earl Warren replaced Chief Justice Frederick Vinson, who died earlier that month. Since the Senate was in recess at the time, his formal confirmation hearing was held March 1954. John J. Flynn, Ernesto Miranda's defense attorney, accepted this case pro bono for the ACLU that year. He asked for the assistance of John P. Frank while defending Miranda in the Supreme Court case. The platform that Flynn and Frank built for the case was that the police clearly violated Miranda's Fifth Amendment right to remain silent and his Sixth Amendment right to legal counsel. His confession was illegally obtained and should be thrown out. His conviction was faulty and he deserved a new trial. Gary Nelson, the Assistant Attorney General of Arizona, spoke for the people of Arizona in this trial. Nelson's platform was based on the fact that Ernesto Miranda was no stranger to police procedures. He negotiated with police officers with intelligence and understanding. He signed the confession willingly. The Supreme Court should uphold his conviction as a guilty man of rape and murder. Miranda v. Arizona was argued on February 28th, March 1st, and March 2nd of 1966. The final decision was made on June 13th, 1966. The decision was close, but Ernesto Miranda won with a 5-4 vote. The Supreme Court of Arizona ruled that Miranda's confession was obtained unlawfully and could not be used as evidence because he was not informed of his right to an attorney and against self-incrimination. Chief Justice Earl Warren wrote the majority opinion and was joined by Justices Hugo L. Black, William O. Douglas, William J. Brannon, and Abe Fortas. The dissenting opinion was written by Justice Harlan and was joined by Justices Potter, Stewart, and Byron R. White. Justice Tom C. Clark decided to write up his own dissenting opinion. After the decision was made, Ernesto Miranda was retried by the state of Arizona. At the second trial, his confession was not introduced into evidence, but he was again convicted and sentenced to 20 to 30 years in prison.
In 2000, there was a case that attempted to overturn Miranda v. Arizona and the Miranda rights. On April 19, 2000, Charles Dickerson was taken to the FBI agency for questioning following a bank robbery where his car was seen at the scene of the crime. He admitted to being involved in the robbery after he was told that a search warrant was being composed in order to search his residence. Dickerson later claimed that he was not read his Miranda rights upon his confession, which was a valid statement, and his argument was taken to the district court. The district court suppressed his statement made at the FBI agency, and the Fourth Circuit State Government Court appealed it. The reason that the 18 U.S.C. Section 3501 with the Omnibus Crime Control Act of 1968 was put in effect, where statements are permitted to be used without the person being read the Miranda rights if the statement is voluntary. The Fourth Circuit argued that the Miranda warning was not a constitutional requirement and could therefore be overruled by Congress in legislation. The case was taken to the Supreme Court, where Chief Justice Rehnquist claimed that the Miranda rules were a constitutional decision of the Supreme Court which cannot be overturned by laws passed in Congress. The Supreme Court said that the Fourth Circuit Court overstepped their boundaries when they overturned the district court's decision to suppress the statement. While an attempt was made to overturn the decision made in Miranda v. Arizona, it has not been revisited since then. All citizens in the United States are given the right to remain silent with the Fifth Amendment and protection from self-incrimination with the Miranda rights. It is highly doubtful that this will change any time in the near future. This case has had tremendous impacts on our society today. Anyone taken into police custody is read their Miranda rights and told that they are given the right to remain silent by the Fifth Amendment. This protects anyone from self-incrimination and abuse from government officials in legal situations. There have been attempts to overturn this case and its decision, such as in Dickerson v. United States, but it is doubtful that the Miranda rights will ever be taken away.
Shannon and I believe that the Miranda rights should stay in effect. They contain two major amendments, the Fifth and the Sixth. These amendments have been in place long enough that changing them is changing our nation's platform. These rights protect our citizens from unfair judgment and self-incrimination. Therefore, we should not abolish the Miranda rights. We agree with the Supreme Court decision that Ernesto Miranda's confession was obtained unlawfully and cannot be used as evidence. Since the United States strives for equality, then he should have the chance to a fair, non-incriminating trial just as many others have been and will continue to be.